One of our biggest pet peeves as litigators is when we have a situation that arises where a litigated claim, something that's filed in court or in front of an administrative hearing officer, comes forward where an employee tells a story that we know is completely fabricated, is not substantiated by the facts. And all too often, we go to our clients and we will say, we need to see all of the documentation to show the legitimate, non-discriminatory reason for why you terminated this employee, for instance. Why don't you give us an example of a situation where having good documentation really helped us as litigators in defending a claim?
That's a good point, because we've had a number of clients who are really good at documenting issues in their business with their employees. And I'm thinking of one in particular where it has been enormously helpful in either cutting down the amount of litigation they have or resolving them very early, because we can show with the documentation that was so thoroughly collected by our clients that we can give that to the plaintiff's attorney and say, look, I know your client is claiming that they were fired because they were disabled, for example, or they got sick, or some other protected basis. But we can come back to that lawyer then and say, well, actually they were fired because they didn't show up to work 5 times in 2 weeks. They didn't meet performance metrics. And here's all the documentation where this has been coached to them verbally first, then put into writing, then made part of a performance improvement plan. And along the lines, we have document after document after document after document to show that there is a legitimate basis for terminating this employee because they just weren't performing, as opposed to, you fired me because I'm a man or I'm a woman or I'm a particular race or something like that.
Yeah. And, employers get this wrong all the time. They think that they can give verbal warnings to their employees and everybody's going to remember those verbal warnings 2 or 3 years later. Yeah. It takes just a few minutes, folks, to be able to jot down an email to yourself or an email to HR that basically says, today I sat down with John. I brought to his attention that he's been late to work 4 times in the last 2 weeks. He told me he would try better. Literally would take you no more than 2 minutes to send that email. And that piece of documentation can be what stands between your business and potential risk of exposure or litigation. When you realize that your business is really, truly in need of legal counsel to help guide you down the path to ensure that you avoid the pitfalls and perils, then we would encourage you to please call Koegle Law Group at 661-362-0813, or you can visit us on our website at koeglelaw.com.